you owe a credit union and you wonder how bankruptcy and credit unions get along? If you owe money to a credit union, they usually have a clause in their borrowing contract with you that any collateral you have given them, such as a car title or a second mortgage on your house, is collateral for any other loans, such as personal loans. That's what's known as a cross-collateralization clause. Say that 3 times, cross-collateralization clause. Let's say you made a credit union law for $3,000 and it was a personal loan and you didn't have any collateral, but then you financed a car with the same credit union and you owe $25,000 on that loan. Well, take a look at your credit union papers when you made that vehicle loan, and sometimes even when you made that first unsecured loan. You don't owe $25,000 on the car loan. You now owe $25,000 plus the $3,000 that you owe on the personal loan. Why? Because there's a clause in eensy tiny print that says now any loan you have with them is collateralized by the vehicle. That's your cross-collateralization clause. Let's say that you have a second mortgage with your credit union and you take out a car loan, but then the car is wrecked and the insurance is only going to pay $15,000, but you owe $20,000. So the insurance pays the credit union $15,000, but you still owe $5,000 to the credit union. Since the car is destroyed, it's no longer collateral. But since there's a cross-collateralization clause, you will owe $5,000 secured by the second mortgage on your house. And even if you pay off the second mortgage, you still have to pay off that $5,000 on the car loan, plus interest until you pay it off in order to get your mortgage released. Credit unions claim they keep their interest rates low because they have less losses than other lenders. One way they have less losses is by scaring you and posting the names of anyone who causes them a loss. By not paying, 100%, they post it either on the credit union website or on a bulletin board at the credit union or both. That's called credit shaming. It's a fact of life with credit unions. So look into it, and if you don't want to put up with being credit shamed, we can plan ahead. You go to the credit union and you say, my lawyer at Geraci Law said I should talk to you about my debt here. I'm happy paying it. I'm happy doing a reaffirmation. I don't want you to credit shame me. I'm going to file my bankruptcy and I want to get a reaffirmation on the car loan right away. I don't want to cause you any loss. Most of the time they'll be happy to hear that, and we can pre-plan with your credit union to reaffirm your debt if you want to. So under Chapter 7, if you have a vehicle and you want to keep it and it's financed by a credit union, they'll want the vehicle back unless you sign up on the vehicle loan and any other loans you have with them, because they're cross-collateralized. It's the same under Chapter 13. So the most common cases involving the credit union is if you want to keep the vehicle and you have another loan with them, it's pretty routine as long as you're happy paying, for instance, the car loan and the HELOC loan. In Chapter 13, you simply pay them according to the contract terms. The only complication comes in is if you have multiple loans with them and you're overfinanced, you don't want the car, and that's something we can discuss with you. Please get a copy of each credit union loan so that we can actually read it and see if they're cross-collateralized. You can stop by the credit union and ask them for a copy of the papers and ask them if the loans are cross-collateralized. Then you'll know how to plan and you can make an intelligent decision. And Geraci Law can help you make that decision.